back to part 2 of the Wills and Estates Succession seminar. Today we are going to discuss dying intestate, and that effectively is dying without a will. So when a person dies without leaving a will, they are said to have died intestate. And this also occurs when a person has died with a will, but the will is invalid for some reason or another. So whether that it was executed incorrectly or only deals with part of the estate. And in this case, your estate or your property will be distributed in accordance with the Administration Act, which is how the law sets out how your assets are to be dealt with. Intestacy is often not reflective of a deceased's wishes, and it does sometimes result in undesirable distributions and tax outcomes for surviving relatives. So the process of who is entitled to your estate if you pass away can be complicated, and it does depend on a number of factors. The law sets out quite a comprehensive table that, depending on your situation and who survives you, will depend on where your estate goes. There is a common misconception that the government is automatically entitled to your estate if you die intestate. This is not true. There are a range of different options before you get to that point, and typically the government would only be entitled to your estate if you have no surviving family or relatives. So like I said, the law sets out the process for determining who is entitled depending on who the deceased leaves behind. So spouses, children, siblings, other family members. As a bit of an example, let's talk about a family situation where there is a mum, a dad, and 3 children. Mum and dad are married, and we've got some minor children. Who's the children to both of them? We have a family home which is registered to mum. Mum and dad each have a car, and then mum and dad have joint bank accounts. So when we're looking at mum's estate, it consists of the family home that's in her sole name, the car that she owns, and also the bank account that are in her joint names with dad. Because the bank accounts are in joint names, typically that would automatically go to dad. So we're leaving mum with the family home and the vehicle. Let's just say, for argument's sake, the family home is worth 500 grand and the car is worth 20 grand. That leaves mum's estate at a value of 520. So if mum dies leaving behind dad and the children, what will happen to her estate and how will that be divided? So if we're looking at the Administration Act, the first question to be determined is, did the deceased, which is mum in this instance, have a husband, a wife, a de facto partner? In this instance, there's dad, the husband, so the answer is yes. The next question then is, did the deceased have kids? Mum and dad had 3 children, so again, the answer is yes. The next question is then, what is the value of the estate? Now, the law sets a threshold which at the date of this presentation is $472,000. Now, in the example, mum's estate is worth 520, comprising of the house that's 500 and the vehicle that's 20. So this would put mum's estate valued above the threshold. So in this circumstance, because of that, that means that dad would get all of the personal household chattels. He would get the first $472,000, and then he would get 1/3 of the remainder, and then the 3 children would actually share in the other 2/3 equally. So dad obviously will also get the entirety of your bank accounts because they're joint. Now, had the estate been below that threshold of $472,000, then dad would have been entitled to everything. This might not appear to be completely problematic at first thought, given that it's being split between dad and the children, but in practical terms, what does it mean? So ultimately, I guess it does create some complexities in that the house is the big asset, which is worth $500,000. So how would Dad get his 472? Would that be by way of the house being sold, or by him receiving a proportion of the house by ownership, equivalent to that amount, then with the kids? I guess it also creates the issue of the dad having the minor children and being able to provide for them. So a will would solve situations like this. It could have provided for, the house, the car, and everything to pass over to the dad upon mum's death, and then ultimately to the children once dad passes away. Really, there's many situations that could arise. Obviously, we've got de factos, we've got when deceased siblings, and how the law deals with that, like I said, will depend on who is surviving at the time. If someone hasn't made a will and they are legally incapable of making a will, the court can actually intervene and make what's called a court-authorised will. So an example of circumstances in which an application to a court for a court-authorised will might be considered might include where there is a need to adjust beneficial entitlements to account for, example, an estranged child, or there are circumstances arising from changes to relationships or complications. The court will refuse an application for a court-authorised will on behalf of an incapable person if the person concerned, if they're not satisfied that the person concerned is incapable of making a will of their own, the suggested will or alteration to a previous will is one which could be made by the person if they weren't lacking capacity. Is the applicant the appropriate person to be making that application on behalf of the incapable person, and have adequate steps been taken to allow all persons with a legitimate interest to have a say in what happens here? If someone dies without a will, then likewise with the grant of probate, there is a system whereby they will have to apply to the Supreme Court in order for them to be appointed as an executor to be able to deal with the deceased person's estate. And in this circumstance, it's called an administrator, and the process is called letters of administration. So it's very similar to the grant of probate. In situations where there is a will but it is invalid, then letters of administration with the will annexed can be applied for, and that's effectively an application to say, well, yes, the will is invalid, but in substance it sets out the intentions of the deceased, and otherwise it's just to call a letters of administration application if someone dies without a will. In this instance, who would be entitled to be appointed as the executor or the administrator is someone who is entitled to benefit from the deceased estate. So if we're going back to the mum, dad, 3 children example, we ultimately determined that dad and the kids were the beneficiaries of mum's estate. Because the kids were minors, they aren't able to be an administrator, so dad would be the one that would be applying to be appointed as the administrator of the will. That sort of deals with dying without a will. Like I said, depending on your circumstance, it may not seem overly problematic if you were just leaving behind a spouse and children. However, it can cause complications, and it can also result in potential tax impositions and other deficiencies. So definitely recommended that you get a will if you don't have one. Join me tomorrow for the last seminar where we'll discuss enduring powers of attorney, guardianship and advanced health directives. Otherwise, enjoy the rest of your day.